Thank you again for being here. Our first argument will be People versus Tyrone, Washington.
Good morning. May it please the Court, Aaron Mead from the Berrien County Prosecutor's Office representing the people in this case. We are asking for a rather unremarkable holding, that MCL 750.7 has a purpose and that it means what it says. So that when it says that when the term felony is found in the penal code, it shall be construed to mean an offense that's punishable by death or by imprisonment in state prison, it means that. And when you come to 750.227b, the felony firearm statute, which says that it's a crime to to have in your possession a firearm when you commit or attempt to commit a felony, that the word felony is construed just as 750.7 says. In fact, if the definition in 750.7 doesn't apply in a situation like this, then I, for one, am hard-pressed to find an occurrence of felony in the penal code that 750.7's definition does apply to and makes a difference. That is, that it tells you something that you wouldn't have known already from the other section of the penal code. And yet 750.7 can't be meaningless. Nobody disputes that the underlying crime at issue here is punishable by imprisonment in state prison and therefore meets the definition of a felony. And that really ought to be the end of the analysis. The fact that it's labeled as a 2-year misdemeanor in the Public Health Code does not change this. We know from Smith that the legislature can intend a crime to be considered as a misdemeanor for some purposes and as a felony for other purposes. The argument that the defendant makes against that for some reason the Code of Criminal Procedure is unique in allowing us to apply it rather than the definition applied by whatever other code is out there, is that the Code of Criminal Procedure has this special purpose of dealing with procedural matters. First of all, I don't see why there is a basis to distinguish it on that point. I think Judge Swartzel got it right, that, okay, if we're talking about this code, we apply this code. It doesn't matter what code it is. But if there was an argument to be made that the Code of Criminal Procedure is somehow special because it deals with things that were mentioned in Smith, like, for example, habitual offenders and consecutive sentencing and those kinds of what some courts have called collateral consequences of that, then it would seem peculiarly inappropriate to apply that when we're talking about 750.227b, because that statute itself took on those procedural aspects. In 227b itself, you find the provisions for consecutive sentencing and the provisions for enhanced sentence for repeat offenders. So for these reasons, we would hold that you simply apply the definition of 750.7 to 227b. I will grant that it's a more debatable question when the crime itself is defined as a misdemeanor elsewhere in the penal code, as in Baker and Williams. And that's, something that can be discussed, but those considerations aren't present here. We have no competing penal code definition. We only have one penal code definition of felony that applies to 227b, and that's the one that ought to be applied. At this point, I would welcome questions, and if there aren't any, then I would reserve the remainder of my time.
Well, thank you, Mr. Mead.
Thank you.
Good morning. Marilena David Martin on behalf of Mr. Washington, and at council table is Sophia Nelson, both from the State Appellate Defender Office. The legislature did not intend maintaining a drug house to be a felony for purposes of the felony firearm statute. We know this because even within the penal code itself, the legislature has enacted numerous offenses expressly labeled as misdemeanors that are punishable by up to 2 years imprisonment and that would otherwise fit the penal code's own definition of felony. The penal code's definition of felony has not been changed since its enactment in 1931, yet the legislature continues to enact offenses labeled as misdemeanors that contradict that definition. The most recent statute being in this year, in 2018, it will come into effect next month, a misdemeanor in the penal code that is punishable by up to 2 years imprisonment. This shows that when an offense is labeled a misdemeanor, regardless of what the penalty provision is, the legislature intended that offense to be a misdemeanor. This is the rule established by this court in Smith and by the Court of Appeals in Baker and in Williams, 2 cases in which this court denied leave to appeal. The rule does not change just because this offense at issue today is located outside of the public health code. Outside of the penal code. The rule that 2-year misdemeanors are misdemeanors for purposes of the penal code also does not create confusion or inconsistent results, and it is squarely supported by the proposition that specific statutes control over general definitional statutes. This is also not an issue that will affect numerous cases. There are only 4 offenses in the public health code that are 2-year misdemeanors. And across codes, I could only locate 33 offenses that were labeled 2-year misdemeanors, and the majority of them fell within the penal code itself. Every single 2-year misdemeanor on the books is more specific than the general felony definitional statute, and it's most recently enacted or amended than the 1931 felony definitional statute. This allows for a consistent application of a rule already in place. I invite questions at any time.
Counsel, it seems to me that your argument that the penal code also has 2-year misdemeanors kind of cuts both ways. I mean, on the one hand, I take your point, but on the other hand, the fact that within the penal code they can define something as a 2-year misdemeanor or a felony might support your opponent's position. Does it not? I mean, the legislature had a choice within this code to define it as a 2-year misdemeanor or as a felony, and it went with felony. So.
Well, it went with, so the statutes that are enacted within the penal code that the legislature chooses to call misdemeanors,
Yeah.
That is so that they have some function as being misdemeanors in some way.
Right.
The same application applies to a 2-year misdemeanor offense in the public health code or in some other code, because there has to be some type of benefit there for calling this offense a misdemeanor. In the context of the Code of Criminal Procedure, there still is purpose if you treat a misdemeanor as a felony, because the person doesn't have a felony conviction. They're just merely habitualized, or they have increased punishment and probation and the like. But if you treat an offense, the legislature said, we want this offense to be a misdemeanor for some reason. If you then treat that as an offense that can create a felony, then the person no longer receives any of the benefits of having a misdemeanor conviction, and the purpose of the code that the misdemeanor offense was enacted is not fulfilled.
But what is it? What do we do with then the statute's definition of felony? It seems to me that your reading of it would make that surplusage. What do we do about that?
It would not be meaningless if this court rules in Mr. Washington's favor for a couple of reasons. First, there are 2 offenses within the penal code itself that are not defined as felonies or misdemeanors. That's hindering the operation of transporting a vehicle, and also the conspiracy statute. They provide penalty. The legislature provided penalties only. Did not say whether those offenses were misdemeanors or felonies. So in that circumstance, that's an offense where you would say, okay, we need to go look and see if this is a felony or a misdemeanor, and we would refer to the general felony definition statute. It's also relevant and remains, it has meaning if you're considering out-of-state convictions. So, for example, if somebody had numerous out-of-state convictions and those maybe were not labeled as misdemeanors or felonies, and we needed to find out if they were misdemeanors or felonies for purposes of applying any part of the penal code, we would then look to the felony definition in the penal code. That definitional statute serves a purpose when it's needed, but it's not needed in this case where the legislature already tells us that this offense is a misdemeanor. There are also 2 important points about this court's holding in Smith. The prosecutor's position that the Code of Criminal Procedure shouldn't be treated differently, it really cuts against the entire foundation of what Smith was based on. And Smith was because there was a conflict, the court had to look at what the legislature's intent was. And in order to do that, it had to look at what the purpose of the Code of Criminal Procedure was versus the purpose of the Penal Code. The Penal Code actually creates new offenses and defines crimes, whereas the Code of Criminal Procedure merely provides for harsher penalties. So in Smith, the court noted that the social stigma attached to a misdemeanor conviction is less than which attaches to a felony. So a 2-year misdemeanor offense, the court held, could be a felony for purposes of the Code of Criminal Procedure because it was still a misdemeanor and provided the person with those benefits going forward. But here there would be no such benefit because using a misdemeanor to create a felony offense gives absolutely no effect to the purpose of creating that offense as a misdemeanor.
Well, it gives no effect under the Penal Code, but having it characterized as a misdemeanor would continue to allow benefits to be derived under the Public Health Code, particularly those relating to consecutive sentencing, wouldn't it?
That's not entirely correct, because then if you're using maintaining a drug house to create a felony firearm, so it kind of creates...
I'm talking about under the Public Health Code, there would still be advantages.
Again, that's not entirely correct, because once you end up with a felony firearm conviction, that can then be used as the felony that activates the consecutive sentencing in the Public Health Code and activates all of the licensing restrictions in the Public Health Code that the legislature said are not afforded to people convicted of felonies. So there are a couple of licensing restrictions the prosecutor cited in its brief, I believe on page 22 of the AG's brief, in which the Public Health Code benefits would still remain. That's the prosecutor's argument. There would still be some benefits under the Public Health Code. It's not entirely a correct statement, because a person who then is convicted of a felony under the Penal Code because the offense meets the definition of a felony now has a conviction for a felony that can be treated as a felony in the Public Health Code.
Well, I'm not saying there's as much advantage as you might like. I'm looking particularly at Section 7401.3 that provides a term of imprisonment imposed under subsection 2A of the Public Health Code may be imposed to run consecutively with any term of imprisonment imposed for the commission of another felony. This would continue to be a misdemeanor for purposes of the Public Health Code, wouldn't it?
Correct, if it's a standalone offense, not if
I'm not saying all the advantages that you might like would be retained here, but there are some beneficial consequences under the Public Health Code. That's all I'm saying.
Okay, thank you, Your Honor. The other point that this court should take note of in Smith is that Smith's holding that 2-year misdemeanors are misdemeanors for purposes of the Penal Code is not dictum. The entire basis of the Smith holding was because the court was trying to make sense out of multiple codes, multiple statutes, different interpretations, different definitions. There was a muddle that the court was attempting to clarify. And in attempting to clarify that, the court expressly stated that we conclude 2-year misdemeanors are misdemeanors for purposes of the Penal Code. When a court intentionally states what its holding is, that cannot possibly be said to be dictum. Even if this court thinks that holding is dictum, again, Baker and Williams that came after that decision, although Court of Appeals decisions, held the exact same thing, that 2-year misdemeanors are misdemeanors for purposes of the Penal Code. And this court denied leave in those cases. The other point to make is that the legislature has, in the past, changed certain misdemeanors, 2-year misdemeanors, to felonies when they wanted them to be felonies. The resisting arrest statute is one offense that was at issue in Smith and many of the cases on this particular issue on 2-year high court misdemeanors. And in 2002, the legislature changed that offense to a felony conviction because now we know the legislature wanted that offense to be a felony conviction. Maintaining a drug house was last amended in 2016, and that statute remained a misdemeanor for purposes, for all purposes, and the legislature could have changed it to a felony.
Counsel, good morning. Welcome to the court. I just have a question, though, and I've just been trying to kind of grapple with this. Does it matter what type of narcotics were sold within the drug house when you're defining it as a drug house?
I don't know the answer to that question.
So, like in this situation, what were we dealing with? What were the drugs that were in question?
In this situation, there was residue of cocaine that was located in a house where Mr. Washington was at. So he was in a room of a house that had multiple occupants, and the police found residue of cocaine on various surfaces.
I understand. But the question here is the definition of a drug house. We don't get into an intensive discussion as to what that ultimately means, right?
We do not, because we're not contesting the validity of the maintaining a drug house conviction.
I see. Okay.
Just the fact that maintaining a drug house, given its misdemeanor label, cannot possibly be a felony for felony firearm purposes.
I see. Okay. Thank you, counsel.
You're welcome. The other statute to point this court to, again, in support of legislative intent here, is the conspiracy statute, 750.157A, where the legislature punished an offense if the commission of the offense prohibited by law is punishable by imprisonment for 1 year or more. So here, the legislature could have said felony, because we all know that a felony is punishable by imprisonment of 1 year or more, but that wouldn't have made sense in the context of the penal code, where we know that the penal code the legislature oftentimes contradicts itself within its own code when it continues to establish 2-year high court misdemeanors that otherwise would fit the felony definition. The fact that maintaining a drug house, again, is in a different code should have no bearing on the analysis of this case, because this is a statutory construction argument, or analysis rather, where the codes are read together as one. The public health code contradicts the penal code in this circumstance. The prosecutor says, 750.7 is unambiguous on its face, it should be applied as is. But we all know that unambiguous statutes, when read together with other statutes, can then become ambiguous. And then what does the court do when it's faced with that ambiguity? The court then applies principles of statutory construction. And here, where the statute of maintaining a drug house is more specific and most recently enacted, this court should find that that's the statute that is sufficiently satisfactory of the legislature's intent in this case to treat this offense as a misdemeanor, not a felony for purposes of felony firearms.
But counsel, why, just if you can go back to the point you had made originally, why is this not jurisprudentially significant? And I just want you to highlight again, because I just wanted to kind of follow that a little bit, as to the fact that you haven't come across too many cases that are relevant to this one. So if you could just expand on that a little bit more as to why you don't feel that the court needs to address this because it's not an underlying problem.
And the point I was trying to make is there are only a very, very few, limited amount of 2-year high court misdemeanors on the books that I could locate. So I located across codes about 33 of them. And 19 of them are within the penal code itself. So if you assume that the specific controls over the general within the penal code, which I don't think is which is debatable, then you have even fewer offenses where the analysis would even have to take place. So it's not significant, and the reason why this court should deny the prosecutor's application for relief to appeal, because it's not going to affect many, if at all, cases. This is the first case on this issue that's come before this court in a very, very long time, and there aren't many cases with this debate because typically people are also charged with felonies when it comes down to it, and there are very few circumstances where individuals are only going to be charged with a misdemeanor offense and in using that to support the felony firearm conviction. That I ask this court to deny leave to appeal.
Thank you very much. Appreciate your argument. Mr. Meade, did you want to respond?
Yes, briefly to a few things, Your Honor. Thank you. Counsel mentioned a couple of other places that she thought 750.7 would apply other than to situations like 227B, thereby rendering it not surplusage if the court disagrees with our position. One of them was a couple of offenses apparently in the penal code that are not defined as felonies or misdemeanors. That doesn't bring 750.7 into play, because what 750.7 says is that when the term felony appears in the act, this is how you construe it. If you're looking at those offenses that she's talking about, you're not having an incident of the word felony show up. That's what 750.7 is. It's telling you how to construe a word when it appears in the penal code. If it isn't there, 750.7 isn't triggered.
Well, how would you handle it if one of those were the predicate offenses? How would this court deal with this?
Well, that would be a difficult one, I agree.
All right, we can leave that for another day.
Okay.
See how my mind works? You get me off on like some other, I'm going to decide some other thing.
And then the other one was out-of-state convictions, which for the same reason 750.7 wouldn't apply to, because they don't involve an occurrence of the word felony in the penal code. That's all that 750.7 addresses.
So when you have an out-of-state conviction, what do you do now? What do we do?
I believe you look to the Code of Criminal Procedure, which I think, if I'm correct, does address how you score felonies from other
Really?
states. At least we do it all the time.
So we
in our
look to the
PSIs.
Code of Criminal Procedure when it's an out-of-state conviction, but we,
Oh, I'm sorry. I thought you were saying to categorize them for such things as habitual, all that sort of thing that happens at sentencing. But you're talking about could an out-of-state conviction
Yeah.
form the basis
Yeah.
for felony firearm?
yeah, what would we do?
I'm
You have
not
that case tomorrow,
sure.
what are you going to come into court and tell me to do?
I don't see how an out-of-state conviction, that the person could be committing a felony firearm in Michigan while,
Yeah, maybe
Committing
that's
an
not what we do.
out-of-state
Yeah.
conviction.
So that's not a real,
that's not going
worth
to,
worrying
that won't
about.
happen,
Okay.
basically.
So we only have those couple of undefined offenses in the penal code,
Right, right. you know.
and that one we're going to leave for another day.
Yes. I mean,
Okay.
there are provisions of the penal code that talk about, if there's a statute where no penalty is provided, then you
Yeah.
call it a misdemeanor. But if these are other felonies, well, if the other crimes where it provides a felony or provides a penalty, but doesn't call it a felony or misdemeanor, then you have to ask, what is the penalty that provides? If it's imprisonment for, that's servable in state prison, and you might argue by analogy at least that 750.7 would apply, even though you're not encountering the word felony. That's about the closest that I could get in that situation, I think.
Your time is up,
But
Mr.
actually,
Mead.
but I'm asking a very quick question, but counsel, should I be concerned or should the court be concerned about ambiguity? Like, is there a concern or a cause here for ambiguity?
I don't think there's anything ambiguous about 750.7 or its application to 227B. Even if a crime is labeled something else, say, for example, in this case, in the health code, or even, I would argue, and again, the court doesn't have to reach this, elsewhere in the penal code, it doesn't change the fact that when you get to the felony firearm statute and it says, if you commit or attempt to commit a felony while you have a gun, you get this extra punishment. You still look for, well, how do I know what a felony is? You look to 750.7, not to the occurrence of the word misdemeanor elsewhere in some other code. The legislature, I think, clearly intended to punish certain kinds of conduct with that, and that's shown in part by the fact that you can even get a felony firearm conviction under 227B for an attempt to commit a felony. And because some codes have 2-year felonies, including the penal code, you can get a felony firearm conviction for doing something that is punishable by only a year. So I think it is meant to be fairly broadly applied. And I don't think there's anything ambiguous about those two statutes interacting together.
Thanks, counsel.
Thank you.
Thank you, counsel. The case will be submitted.